This panel is going to explore the role of courts in monitoring the application of law to counter terrorism in the fight against terror. We have been discussing throughout the day issues relating to the norms, to the laws that should apply, that could apply, issues relating to morality, issues relating to effectiveness, to legitimacy. But this panel is designed to bring us back into the courthouse and ask what is it that courts are doing in the context of the fight against terrorism, because I want to draw on a very famous quote by Oliver Wendell Holmes in his important 1897 article called The Path of Law, which laid the grounds for what is called legal realism, where he has written that the prophecies of what the courts will do in fact, and nothing more pretentious, are what I mean by the law. Namely, that it is what the courts actually do is, realistically speaking, often what the law is. And this is very important in this specific context of the war on terror, because a lot of the logic of the war on terror since 2001 onwards, both in this country but also in Israel, has been to take away government policy and remove it from the purview of the courts. This may not have been the raison d'être, the underlying reason of these policies, but this has been certainly the effect of these policies, because once we have stopped treating terror as a crime, which should be primarily as a crime that should be fought with law enforcement tools, by the police, and we have seen it more as a military problem, as an intelligence problem, that should be fought by the military, that should be fought by security intelligence agencies. And these agencies often operate overseas. We have created conditions under which the ability of courts to exercise powers of review over issues such as drone strikes that we've been discussing today, or secret surveillance policies that we have heard about today, or even certain detention policies in black sites, what have you, interrogation techniques. All of these activities have been removed from law enforcement and put in a very different organizational context that has made the job of courts so much more difficult. And even when these cases did arrive to courts, in Israel many of them did arrive, but also in this country, some did arrive. The logic of the law enforcement framework, which informs judicial supervision, is very difficult. Is very different from the logic of military operations and the applications of rules of law in that specific context, and that made the challenge of exercising meaningful judicial review very difficult. So for instance, whereas in the criminal law context, we are punishing individuals because of bad things that they have done, and we assign to that legal responsibility, here we are more concerned about bad things that these persons may do in the future. So it's a preventive logic which is very different than the punitive logic that we apply in the criminal context. If in the criminal context, the basic principle of assigning criminal responsibility is reasonable doubt. We do not convict. We prefer 100 guilty men to be released. We prevent 100 men to be released than one innocent being convicted. This is not the logic. This is not a framework that has been applied and probably can be applied in the context of counterterrorism. Here we are talking about reasonable risks, etc. And here, whereas the court system operates under an ethos of publicity and an open door policy, here a lot of the stuff that we are dealing with is very secretive. So it's a question whether courts are in the business of monitoring the application of the rules of law in the context of counterterrorism, and whether they can be and should be in that process, given what we know about the difficulties in exercising judicial review. And we have a very good panel to discuss these issues. I'll introduce very briefly the panelists. Their fuller resume is in the information package that you have received. Our first speaker would be Professor Ashley Deeks, who's faculty on the at the University of Virginia. She has joined the University of Virginia in 2012. After 2 years as an academic fellow at Columbia Law School, Ashley teaches international law, national security, and the laws of war. Before joining Columbia, Ashley Deeks served as an assistant legal advisor for political military affairs in the U.S. Department of State's Office of the Legal Advisor. I should also note that she has served as an embassy legal advisor in Baghdad in 2005. She was a member of the council, a fellow on the Council of Foreign Relations, and she's a graduate of the University of Chicago Law School. Our second speaker, who may need no introduction in this particular setting because he's a local GW. Professor is Professor Peter Raven-Hansen, who teaches national security law, counterterrorism law, and civil procedure and evidence. He's well known in this country, I would imagine, particularly for being the co-author of very prominent case books, both on civil procedure and understanding civil procedure, but has also written on the topic of national security and the use of nuclear weapons. Before joining the faculty in George Washington, Professor Raven-Hansen was in private practice in the law firm of Hogan & Hartson here in Washington, D.C., and worked as a senior economic analyst with ABT Associates Incorporated in Cambridge, Massachusetts. He currently assists in civil litigation under the Anti-Terrorism Act and appeared in a variety of U.S. and international forums. And our final speaker, Justice Dorit Beinisch. Dorit Beinisch has began her professional career in 1966 at the Ministry of Justice in Israel, where she served first in the District of Jerusalem, in the District Attorney's Office, and then moved to the State Attorney's Office, where she headed the Supreme Court Division at the State Attorney's Office, being responsible for all administrative and constitutional litigation before the Israeli Supreme Court. In 1989, she was appointed as the first woman to hold the position of state attorney of the State of Israel, and was appointed in 1995 to the Israeli Supreme Court. In 2006, she was promoted to President of the Israeli Supreme Court, what is called here the Chief Justice, again being the first woman to have held that position. Justice Beinisch is a graduate of the Hebrew University, where she has received both first and second degree. She is also an honorary doctorate of the Hebrew University and has served in the last 3 years as a visiting professor. And we have had the pleasure of co-teaching a course on national security and human rights last year, which was a very memorable experience for both of us, for reasons which cannot be divulged at present. Dorit Beinisch is also the Chancellor of the Open University of Israel. So Ashley, let's get the ball rolling.
Good afternoon. Thank you, Yuval, for the introduction, and thank you for inviting me to speak here today on a very interesting topic. I'm going to divide my comments into two parts. In the first part, what I want to do is very quickly highlight some of the difficulties that our courts, the U.S. courts, have had in wrestling with and adjudicating cases related to military operations and intelligence operations. And I will talk a little bit about what some of the limits of judicial review over these operations look like. And then I'll take a quick turn to some other quasi-legal features of our system that I think do help to constrain, in some ways, these military and intelligence operations, even if they are not strictly inside a U.S. courtroom. So I think my message there will be that all is not lost in terms of proper oversight over these activities, but that it's useful to think about ways to shape and amplify these quasi-legal constraints as maybe a second-best substitute for what some people would like to see is robust judicial oversight. So let me start with the first part. This question's about what are the hurdles to judicial oversight of US military and intelligence operations? And I should say up front that a lot of these hurdles are not necessarily unique to counterterrorism, and a lot weren't created specifically in the context of counterterrorism. They are rather kind of longstanding constitutional, jurisdictional hurdles or statutory hurdles. And this is also all colored by a longstanding perception in the US courts about their constitutional limitations and their institutional constraints on adjudicating these complicated cases that often involve politics and often involve intelligence activities. We did see a number of cases as far back as Vietnam that helped shape these doctrines. So these are not just, have not just developed since 9/11. So let me start by talking about some legal hurdles. One legal hurdle is called standing. And the idea there is you're asking the question about whether the court will ask whether the litigant before it is properly suited, has a case in controversy that the court should adjudicate. And one of the questions the courts will ask is, well, is this somebody who has suffered an injury in fact? And is there a connection between the injury that the person is suffering and the complaint, which he raises before the court? And would a positive opinion by the court help mitigate the injury? And in a number of counterterrorism cases, we have found courts conclude that the person in front of them lacked standing. So a recent prominent case was a case involving Anwar al-Awlaki's father. So Mr. Awlaki was somebody that the United States killed in Yemen, but before he had been targeted, his father brought a suit in the District of Columbia District Court saying he was seeking various relief, and the basis for his presence in the court, he was claiming that he was the next friend of his son, because he said, my son is not in a position to be able to come forward himself and present his case. And the court basically found that he did not have appropriate standing to bring that case. And so the court said, look, Mr. Awlaki could come himself and raise these claims, and it's not for his father to do so. We've seen other standing limitations in a case called Clapper versus Amnesty International, where a number of individual lawyers who worked with controversial clients overseas claimed that they were being surveilled by the government under Section 702 of the FISA Amendments Act, and that was unconstitutional, and the Supreme Court found that it was actually the harm to these individuals was too speculative, that they basically did not have standing. So that's one category, is standing. Another question in which courts often invoke a doctrine to push back against hearing cases like this is the political question doctrine, which some of you may have heard of. The idea here is that the question presented to the court it's a kind of question that's been allocated specifically to the political branches. And furthermore, there might be a situation in which the court says, there aren't really manageable judicial standards for us to assess the question. So again, in the Awlaki case, that was a second ground on which the court decided to dismiss the case. It said, questions related to intelligence like this and when somebody poses an imminent threat to the United States such that the executive should be able to use force against them, that's a political question that we are not in our guise as a court suited to answer. Okay, so a third category that courts have often used or accepted as an argument to stop the adjudication of a case is the state secrets doctrine. This arose in a number of rendition cases. So you may recall that the CIA had established a rendition program, and a number of individuals who had been rendered sought to come before federal courts and claim that a number of rights had been violated, whether constitutional or statutory. And the government said responding to these cases would inherently reveal important state secrets that would compromise U.S. national security. And sometimes these cases were actually against contractors of the CIA, not against the government, but the government nevertheless is able to invoke this to stop the case. And in these cases, the courts accepted this argument and dismissed on the basis of the state secrets doctrine. Final category, well, I'll just quickly flag two more. There's a doctrine of qualified immunity, where the action doesn't necessarily violate what are called clearly established statutory or constitutional rights. So the court might say, well, yes, this does seem to be problematic, but at the time that the government actor did it, it was not clearly established that it would have violated the Constitution. That came up in a case that Mr. Jose Padilla brought against John Yoo, who had been an attorney in the Department of Justice. And there are also other doctrines such as ripeness, that the claim isn't ripe yet for the court to hear it. And in general, courts have expressed very significant deference to the executive in this area. So in FOIA cases, the court shows a lot of deference to the executive. It often shows a reluctance to create what are called Bivens remedies for constitutional violations. These are implied remedies, and the courts generally say, look, we're going to look to Congress to tell us when we should award damages for the kinds of violations that the plaintiff is claiming. Those are a set of legal hurdles. Yuval has already referred to some of the practical hurdles that arise in terms of getting cases to courts. First, a lot of the operations that we're talking about are often either clandestine or covert, so it may be hard to discover that a particular thing has happened. And even when you do know something's happened, the operations often take place overseas, generally take place overseas. It might be harder to identify those who have been negatively impacted by such operations, and it may sometimes be hard to identify the author of the operation. There are a lot of actors these days engaged in military and intelligence operations. So that's the sort of in a nutshell, the kinds of things that make it hard for people to bring claims in U.S. courts related to these kinds of operations. Okay, so where does that leave us in the absence of an aggressive sort of set of federal courts looking to take on these issues? I'm going to suggest that there are three possible alternatives that we should think about when court cases prove impractical or a difficult way to regulate counterterrorism operations. So one set is external to the executive, and I'm not going to say much about it, but I know, for example, that the United Kingdom has something called the Iraq Historic Allegations Team, where they've set up a body to look at alleged violations of the laws of war by US forces in Iraq. So it's taken it out of the court system per se, but they have a kind of standalone body to assess those particular questions. But some, I think, are more internal to the executive branch itself. And so here, I want to suggest three possibilities. One is something I called the observer effect. And what I mean here is, it's a general phenomenon. It appears in physics, it appears in psychology, and it's this idea that you can affect an operation by just watching it. So I think that this happens, actually, between the courts and the executive, even in cases in which the court doesn't come in and rule on the merits. So if there is doubt in the executive's mind about whether a court will step in to review a particular program of the executive branch, I think that affects the way the executive shapes a given policy. And the court might do this through language in past cases, it might do it through dicta, but the executive pays very close attention to these prior judicial decisions. And I think the executive sometimes alters the scope of its policy to either avert judicial involvement or to make it the policy itself more palatable if a court were to decide to step in. So just to give you one example, the executive established administrative review boards to give Guantanamo detainees a kind of review before the Supreme Court came down with its Rasul decision. And I think it created this administrative review board, the series of boards, in part to shape the court's opinion. We can also find the executive revealing what previously had been secret policies as a way to cast its activities more favorably for the courts. So in the context of some ongoing litigation from Guantanamo detainees, the US government reveals its policy related to diplomatic assurances, which are basically commitments it gets from other governments that the person they're transferring won't be mistreated. The government had not said much about it and had said that's a classified thing, but I think in order to present it a more favorable foot forward to the courts, it revealed the process by which it obtains the assurances. So that's the first thing, is this observer effect. A second place that constrains the executive is what we might think of as peer constraints. So By this, I mean other intelligence services who work with U.S. intelligence services have a pretty significant influence on how they do their business. And the idea is that the legal constraints on this other intelligence service actually affect how the U.S. intelligence service conducts some of its operations. So there are news reports that the German intelligence service had decided that it was unlawful to share a terrorist cell's location with the U.S. government if it thought that the government was actually going to use force, military force, against that person. So it gives the U.S. government two choices, right? It can either agree to the German government's conditions on accepting this intelligence, or it can refuse the intelligence. But that's the kind of thing I want to suggest can also constrain the executive. And this can, note, include a role for foreign courts. So Germany's policy might be influenced by the European Court on Human Rights or the German Constitutional Court. And so it's a sort of transitive way for other courts to affect US policy. And the final thing I'll suggest is there's been a fair amount of interesting academic work on this idea of interagency checks and balances, right? So a perfect system of checks and balances, or as perfect as one might get, is Congress, the courts, the executive. But that, as we've talked about, has broken down in a number of ways. We've talked a little about the courts, but also the Congress has not provided very much robust oversight. So another place to look is what are the checks and balances that exist within the executive branch? Tensions to, each agency has particular equities and has particular issues that they really care about. And so I think if you look inside the executive branch, there is a fair amount of struggle over what the correct policies and legal policies are. And I think even inside a given agency, you can find some interesting checks and balances. And I think these are maybe places to explore a little bit more as alternatives to the extent that the courts have proven unable or unwilling to robustly step in. So with that, I'll turn it back to Peter.
Thank you very much. The panelists talked before we got up here, and we decided we were in a black hole in this afternoon. You know, the sugar high is gone. You've heard from Secretary Chertoff. You're about to hear from the former president of the Israeli Supreme Court, a justly respected jurist. She will be followed by the former Attorney General of the United States, himself a justly respected jurist. We are in a black hole, the rest of us, you know. So let me start with a historical anecdote. My subject is secret evidence in criminal trials of terrorists, but I want to turn your attention to 1603 and the trial of Walter Raleigh. And it's to illustrate the fact that the secret evidence problem in national security prosecutions is not new. And it's based on my exhaustive research on Wikipedia. I read almost the entire entry. Walter Raleigh was prosecuted for conspiring to commit treason by killing the candidate for the throne. And at his trial, almost the entire Crown's evidence was the sworn written confession of his co-conspirator, Lord Cobham, who said that he didn't really want to do it, but Sir Walter Raleigh talked him into it. And so Raleigh, acting in his own defense, predictably said, you know, can I see this guy? Bring him into court. Let me talk to him. Let me find out why he signed this confession. And the prosecutor not only refused to bring Cobham in, but he brought a witness, a boat pilot, who testified that he had heard a Portuguese man say that the wannabe king would never become king because Raleigh would first cut his throat. And Sir Walter Raleigh said to that, as you might expect, what kind of proof is this against me? I mean, that's literally his phrase as Wikipedia recites it. Today he would say, you call this proof? To which the prosecutor said, and I quote, "It must perforce arise out of some preceding intelligence and shows that your treason had wings." And he was convicted. Later released and then re-imprisoned and executed. I think, in fact, he was drawn and quartered just to make the point. The case is remembered basically as the origin of the Confrontation Clause because it involves hearsay, obviously, and the question was, how do you test the accuracy of hearsay without having the declarant in court? But I also think it illustrates two central problems of secret evidence in criminal prosecutions of terrorists. The first, from Walter Raleigh's point of view, is obviously that he can't test the accuracy of the evidence against them without knowing what's behind it. It's not just seeing the declarant, it's understanding what the prosecutor has cherry-picked from all of the so-called preceding intelligence in order to make the case against Rowley. What exculpatory information has he left on the table? What other stuff was he told? Who were the other co-conspirators? And so the problem from the defendant's point of view is obviously being able to defend and rebut without seeing the evidence, is a near impossibility. On the other hand, from the government's point of view, they want to protect sources and methods. Was the Portuguese man, was the boat pilot an informant? If so, we don't want to bring him into open court and show who he is. The preceding intelligence that the prosecutor talked about may consist heavily of sources and methods, and you have to protect it if you're going to continue to successfully counter treason, or in our case, terrorism. So what I want to talk about is 5 techniques that the civil criminal courts have used in terrorism prosecutions and espionage prosecutions, and whether they've worked. So one technique, of course, we might try is simply to go ahead and try terrorists on secret evidence. The stakes are great. The sources and methods have to be protected. Maybe we should just go ahead in that fashion. Clearly, the Confrontation Clause prevents that. Thanks maybe to Walter Woolley's trial, the Confrontation Clause requires the government to present witnesses in live court and allow them to be cross-examined. It's also been interpreted to include documentary evidence, but even if it wasn't interpreted that way, the courts have consistently said over 200 years that a baseline principle of American law is that the criminally accused must be allowed to see the evidence against them, period. This is not a balancing test. Sometimes we talk about procedural due process as balancing the government's interests against the defendant's interests and trying to decide what process would make the outcome more accurate. The baseline rule of disclosure of evidence to the criminally accused is not a balancing test. It is not due process in that sense. It's a fundamental of American law. There's no cost-benefit analysis. So that first option, not showing him the evidence, is out the window. How about this one? Let's show the defendant the gist of the evidence, just the core evidence against him, and let him respond to that, a system that's used in some other countries that we may hear about. I don't know a defense lawyer in the country that would go for that option because it lets the prosecutor decide what the gist is. Even with the supervision of an Article III independent judge, that's not satisfactory to any defense lawyer. And often the evidence that's going to be offered against them, whether it's gist or not, is evidence that only the defendant himself can really appraise. Was it a comment by a former wife who has an axe to grind? Was it translated accurately? What's the context? Who would know better than the defendant himself? Now, before we leave the gist possibility, we have a Classified Information Procedures Act, CIPA, it's called, which seems to allow something like the gist of the evidence to be presented, not the whole thing. So let me describe that briefly, although this is a heroic thing to do on the afternoon because CIPA is incredibly complicated. It is a statute that was enacted to deal with Graymail, which is to say a defendant's threat to use classified information in his defense or to discover it that would force the government either to drop the prosecution or disclose the secret information. And what the statute does is simply create a pretrial procedure for a court to look at the information in camera, out of the presence of the public, and decide whether it's admissible. And then if it's admissible, to turn to the government and say, you either disclose this or propose a substitute in the form of a summary or a stipulation that will allow the defendant to make the same defense he could with the underlying classified information itself. So that's the standard, the same defense. That sounds like a technique for showing the defendant the gist of the information, with the court's approval that it's an adequate summary. But it has not been used that way. It was used primarily with respect to defendants who already had classified information, espionage defendants who threatened to use what they already knew in order to force the government into the disclose or dismiss scenario, or it was used by defendants who sought discovery of classified information, hoping to put the government in the same position. I don't think it has ever been used in any criminal prosecution in a national security setting for the government to present the bulk of its case against the defendant in the form of a summary, in the form of the gist. And in fact, it would be extremely difficult because the courts are already struggling with approving summaries on a more limited basis I've described. Let me quote one case, United States versus Marzook. Some of you may recall, I think it was Hamas terrorist Marzook, prosecuted in a federal court in the Midwest. The judge said, quote, "It's a matter of conjecture whether the court performed any real judicial function when it reviews classified documents in camera without the illumination provided by adversarial challenge and with no expertness in the field of national security. The court has no basis on which to test the accuracy of the government's claims." So the courts, in this kind of candid moment, are already acknowledging that it's awfully tough in an in-camera proceeding, usually conducted ex parte, just the government lawyer there before you, to evaluate whether the summary is sufficient. In another terrorism prosecution, also in federal court, the judge decided that the way to compensate for his lack of expertise was to go to the CIA headquarters in McLean and have the CIA brief him on the importance of the classified information. This was Judge Rosen, our own alum. And I think that's an admirable effort at self-education, but the optics of it don't look so good. This is an Article III judge going to the CIA headquarters to hear about classified information. I mean, the problem, I think, is self-evident. In fact, the government has once in a while tried to use SIPA in the way that I'm describing that they shouldn't and couldn't. In United States versus Abu Ali, Abu Ali was a al-Qaeda terrorist who was rendered from Saudi Arabia to the United States for prosecution here. The jury was shown unredacted information, but the defendant was only shown a redacted version of it because some of it was classified. And the Fourth Circuit Court of Appeals, which is not known as a particularly liberal court, said that the notion that the court's ex parte approval of redactions could justify a conviction on secret evidence is patently absurd. We don't balance a criminal defendant's right to see the evidence which would be used to convict them against the government's interest in protecting that evidence from public disclosure. So I don't think that using the gist of the evidence, even under judicial supervision, is a way to go here. All right, so how about this third alternative? Let's show the defendant the evidence, but close the trial to the public. The defendant will see it, but we're going to convict him, and he'll be in jail for the rest of his life under special administrative measures, SAMs, so he won't be able to communicate with anybody. We trust the judge. He's a life-appointed Article III judge. We can security clear defense counsel. And the jury, well, let's forget about them for the moment. The problem with this is two constitutional hurdles. First of all, the Sixth Amendment guarantees criminal defendants the rights to a public trial. That's the language of the Constitution. How do you get around that if you're trying to close the hearing? And secondly, if the defendant agrees to the closing of the hearing and has waived his Sixth Amendment rights, we, as the public and the media, as our representatives, have a First Amendment right to attend the trial. It's not absolute. The courts have said if there's no tradition of access to a particular judicial proceeding, and if it would serve a high interest of the government to close it, and if the closing was narrowly tailored to protect that interest, then sometimes we close hearings. For example, we may close pretrial proceedings in criminal cases involving minors. But in 1948, the Supreme Court looked, they had some clerk, I'm sure, do this, and they said they couldn't find a single case at the federal level, at the state level, at the municipal level in the United States history since the dawn of the Republic in which a criminal case had been closed. So there's no tradition of closing it, and I can't see that as an option here either. So here's a fourth option. Let's not close the whole thing. Let's just close parts of the hearing involving sensitive witnesses whose identity or whose testimony may involve classified information. And this actually is a technique that has been used from time to time. It's called the silent witness rule. And you have to imagine that, for example, the classified information consists of the fact that a certain foreign state provided money to a confederate of the terrorist, but we don't want to embarrass the foreign state. Under the silent witness rule, the witness will say that country X gave W money to Mr. Z, but the jury and defense counsel and the defendant and the judge will all have a code that tells you who X, Y, and Z are. It's just that the media and the public won't know. So will that work? Well, it has been approved. It was approved recently in a very controversial espionage prosecution in the United States versus Rosen, which some of you may know about, that involved the leaks through two members of AIPAC. But the judge was awfully anxious about permitting this technique. First of all, he said, I'm not going to permit it wholesale. There are not going to be multiple witnesses. They're going to be used or testify under this secret witness rule. And secondly, he openly worried about the fairness of even allowing some witnesses to do this, because for one thing, it's confusing. You know, jurors are no more awake in the afternoon than you are. And for them to hear that X gave Y, Z money is almost guaranteed, you know, to lose their attention. And secondly, it's extremely hard to cross-examine effectively. Isn't it a fact that Z gave W to Y? You know, that's not a Perry Mason moment of cross-examination. And I was going to say Perry Mason is just for my age, but as I looked at the crowd, I know you're my age, so, you know. Also, there's a problem from the perspective of the public attending the trial. At some point, it's confusing to them. I mean, the whole purpose of the First Amendment right of access is that we can monitor what goes on in our criminal courts. We can watch the performers, including the judge. And the less the script is understandable to the jury, the less that function is fulfilled. So I think the secret witness rule may have some very limited applications, but it's not an answer to protecting classified information. So none of the options sound very good. And if you thought about this carefully, you also realize that all but the first, that not giving the information at all to the defendant, have two flaws. One is that the defendant gets it, you know, so if he is acquitted, he walks off with the classified information. And the other is that the jurors get it, and they're not security cleared, although they're usually admonished at the end of the trial, you know, not to talk about that information. So those are flaws that kind of are common to all of these. So let me leave you with one other option: declassify. You know, now that sounds glib. It sounds like the economist who's asked, you know, to help somebody out of a deep hole and says, assume a ladder, you know. Am I making the classified evidence problem go away by saying declassify? It's actually not so unrealistic. First of all, everybody in Washington agrees that there's massive over-declassification, massive over-declassification. So the very fact that something is classified hardly makes it a secret. Secondly, prosecutors don't get a box of evidence with which they then go and convict. They pick what goes in the box. So they can pick and choose to some degree here. And third, they also make a charging decision that fits the evidence. So they have an unusual ability to sculpt the case in such a way that they might be able to prosecute and convict on public information, unclassified information, avoiding most of the problems I've described. In the embassy bombings trial, the defense counsel said that virtually every time they challenged classified information, the government had it declassified, sometimes overnight, and the evidence was then used. And the prosecutor, Mr. Fitzgerald, said declassifying the information made our lives a lot easier. So there is a solution. It won't work in all cases, but it's, you know, more feasible than one would think. And let me leave it with that.
Good afternoon. Well, I'm the last in this, I think, this very interesting day. It was, I think, that you covered in all the panels so many important topics for discussing. The last comments that we heard about classified information or secret evidence is really intriguing for me. But as this is not an interesting, very interesting, and a problem for every court. But I'll try to talk from my main point of view as a judge, and as being years actually as a prosecutor in law enforcement, and in later years as a judge in the Supreme Court. And the first question is, do we judges have a role in times of war against terror. And those of you who had the opportunity yesterday, I already mentioned that my view is, of course, that we do have a very important role. And the answer is an affirmative if you think, what did we discuss today from the first session in the morning? We discussed interrogations and torture came to our court. We discussed collecting intelligence technology, all those problems, classified information, all of them were targeted. Killings, of course, all of them came to the Israeli Supreme Court. Because the question, do judges have a role, I think and I believe we cannot ask that question anymore. This was traditionally the old days, World War II, this was the attitude and the approach of courts. We do not touch security. This is a matter for the other branches of government. This is for the executive, and courts should defer and refrain from dealing with it. And as we know, lessons of World War II and the really dark days that they had where so many infringements upon human rights occurred and atrocities, terrible dark time. We all know that in order to keep our democratic values, we cannot afford not to deal with all those issues, tough issues, very complicated, of security and human rights. We all know that an independent judiciary and a political judiciary will guarantee the democratic values in times of war as in times of peace. And every court in different systems strikes the balance between the public interest in security and the democratic values in accordance with its legal, constitutional, historic, and traditional background. And those are, of course, different, although we share the same values. You mentioned, Ashley, 3 cases that if our court would deal with them, we would decide differently. In Al-Awlaki, saying that his father has no standing, or in Clapper, in the surveillance case, when they had to talk with their clients, actually, the human rights groups, or rendition cases, which fortunately we don't have rendition, but not to touch the case because of secret evidence or certificate, this wouldn't occur in our court. So I don't know, as I said, what is the right decision? Because, as I said, it's part of the system and of the legal background, constitutional background. There were days that courts believed that this means a separation of powers. Technical definition of separation of powers. Court shouldn't touch material that is really in the authority of the administration or the executive. I would like to share with you our perspective on the role of the Israeli Supreme Court in the fight against terrorism. It may not be a model for other courts in other legal systems, but it reflects the needs of our reality as a state that faces security threats as part of its ordinary life, daily life. So it was already mentioned in our discussions, Israel had to confront security problems since its establishment. And if we talk about the era of terror, we had our 9/11, many days of 9/11, in a different way. We had suicide bombers. We had really very, very hard cases of terror for civil population. As I said, and the methods of the terror, of course, everywhere change. But the result is, of course, bloodshed and murder. So now, after we don't have any more, thanks God, I hope we don't have any more, the suicide bombers, we had other methods of terror. We have missiles and rockets from Gaza. Later on, we have those knife stabbing that kill not only innocent people in the streets, but even children in their beds. So we have to adjudicate and decide cases regarding this conflict between those two poles. There are serious problems of security, but there is a serious need to protect our values and, of course, human rights. And we were, as a court, the Supreme Court, were required to strike this balance between clear, really security interest and governments, of course, feel the duty, and they have the duty, to protect their population. This is their duty. The people expect the government to protect them. This is what they want from the government. They don't really care what will be with the rights of terrorists, and they don't even realize that this means actually their own rights too. So striking this proper balance between those two poles, deciding on proportionality of measures adopted is a very difficult task in our reality. But we never thought we can just avoid touching those issues, because this became part of our life, and not only before 9/11, this was our life. I think since 9/11, all the democratic states recognize the danger of terror. So this is a very complex situation, especially because the court sits in Jerusalem, in Israel, where things occur. The public doesn't understand too much. Why do we bother about all this? But we believe that we have to protect ourselves by protecting our values. And actually, the law is the same law in times of terror and in times of peace. Sometimes the balance changes, but not the principles. And the problem, of course, for every court, we judges, we are not experts to decide on effective measures to fight terrorism. We are not generals, we are not politicians, we are not academics. And still we have to give the right answers in the right time. We specialize in determining whether a law, a governmental policy, or a military action is consistent with our basic laws and with our fundamental values. And this is our way, our compass to decide. So we all know that not all means are acceptable in a democratic system. We heard today about the constraints. The question is, where do we put the constraints? This is the rule of law, and this is our role to put the constraints if the executive doesn't put them as they should in times of war or in times of fighting terror. And I don't want to go into the question if fighting terror is a war, not a war, declare the war. It's painful, it's complicated, so we won't go into the legal definition of those issues. But consider almost any issue raised by the fight against terror, and it's very likely that the Israeli court dealt with it. The legality or the illegality of the use of torture, I think it wasn't mentioned today, but this was the judgment where President Barak decided and said this famous saying that democracy has to fight with one hand tied behind. And not everything can be used, and not all means can be used, even in times of war. Torture is an absolute, of course, prohibition. And then we had many, many cases of detention, administrative detention, of course. Unfortunately, we do use administrative detentions, and not only we do that, this is one of the accepted or even controversial, but this is the tools we use in fighting terror. Here comes when we talk about administrative detentions comes the question of what is the evidence? What evidence do we use when we approve the detentions? A very difficult issue. It came many times to our court. Building the security fence, we had about 130 cases of security fence where we had to decide about the proportionality of taking land for security and for real security purposes and not in proportionate taking of private land of people, villagers who use this and it's their own property. All those issues came to the court, not easy decisions. And of course, already mentioned the targeted killing issue. And the use of human shields, the rights given to unlawful combatants. Are they unlawful combatants? What do we do with them? All this came to the Israeli court. And just you name it, we had it. Our guiding principle in adjudicating these cases is that the battle against terrorism must be fought within the law, and that no war may take place outside the borders prescribed by law. How do we do it? And now I want just to mention, I know I have to shorten, it's late already, the 5 aspects of our judicial review that make the Supreme Court particularly responsive to the needs of our time and our wars. First, and I already mentioned it, broad access to the court facilitated by the practical elimination of any requirement of the right of standing. I cannot imagine a father who comes to the court applying to save or not to take means against his son, and we would say, sorry, he hasn't got the right of standing. I don't think that we could interfere in deciding if he should be targeted or not. This is a different question, but not on the cause of the lack of standing. So this opened the doors of the court to human rights associations, to NGOs, to everyone who wants to bring to the court a matter that shows that the law has been infringed. The other very important factor is the court almost never closes its doors or accepts the argument of non-justiciability, which means not only non-justiciability, we don't accept the argument of act of state, political question. This doesn't put a barrier to go into the case. And I think this is the most important. Those 2 tools are actually the most important, so the court can really find the legality of acts done by the, or measures taken by the military. Another important, very important tool is that the court deals with those questions, the Supreme Court, in real time. This is very special for our system, that those issues come directly as the original jurisdiction to the Supreme Court. It's not an appeal court on those matters. So everyone has access to the court, Palestinians from the territories, whoever comes to the court. And if it's an urgent question, while military operation takes place, the court will deal with it the same week. It's not an appeal, it's first instance. We need affidavits, sometimes we summon the military commander, but this has to be decided really in real time. Because if not, actually there is no remedy. It's an historical remedy to tell if this was legal or not legal, but this will not prevent the illegality. And we had many cases like that. If I can tell you something that looks very extreme and strange in other countries, while the military operation, Kasled, let's say in Gaza, took place, people from Gaza, through NGOs, came to the court claiming that the military, the army, doesn't let them. I mean, it was the humanitarian assistance, transfer of wounded people or people to hospitals. Don't let them electricity. And the court was sitting at the time when all this occurred and soldiers were in the field in Gaza. The court was sitting. We had few sessions, all of them discussing and having reviewed what is the military approach to the demands of the population according to international humanitarian law. Another thing that I can bring is we do use international law. Sometimes we have to because it is international law is the basic norm in the territories, but we also think that in matters of fight, of war, we have to accept the principles of the international conventions, and of course to adapt them to the situation. It was already discussed today. They are different. They weren't drafted, they weren't prepared for the war against terror. It's a different war. Yet the principles should be, when we talk about civil population, should be respected. And of course, another feature that and those are the 5 points. After all, this is the Supreme Court that deals with all this, which has an authority that makes it, I hope so, very difficult to the executive not to apply the decisions. And still, they have a lot of respect, and sometimes they're not satisfied, criticizing, yet they have to accept the decision of the court. So actually, and this is how we operate, and I must say, many problems we have to solve ad hoc with the situation. If we talk about classified materials, secret evidence, we have to separate between the criminal cases, where of course it's one thing. You cannot try a person, a terrorist, whoever, in a criminal case without bringing the evidence. We do have we can have a trial in closed doors, what we call, but the defendant has it, and later on, part of it is sometimes published, but there is no classified material in a criminal case, unless you have to drop the case if you cannot bring the evidence. Special evidence, the gist of the matter against the detainee, this is the practice in cases of administrative cases, administrative detentions. Unfortunately, we have many of them. But again, I don't want to criticize, I don't want to compare, but maybe we have too many, I don't know. But the fact is that every detainee has access to up to the Supreme Court, to military courts, administratively, and then a detainee can come to the Supreme Court. So it's not the way we are used to adjudicate cases, because we cannot show the material, but we developed a practice where the court can look with a consent, and only with the consent of the detainee, ex parte, into the evidence, ask questions to the security people, try to find out what's happening, and sometimes, not even in a formal decision, tell the security people, this detainee should be released and not kept anymore. And then most of those cases are not precedents, are practical, a lot of practice, and as far as we know, they trust the court, and they agree. Most of those detainees and their lawyers agree that the court will look into the evidence, decide if to declassify it, and give them the gist of the matter. So we can tell him he's active in Hamas, we know it, we know this and that. Of course, not all the details that could be and should be maybe brought to a president. This is very hard for a court, of course, because our system is, all of us are used to work with two parties and not ex parte with one party, but this is part of the conditions that we have to accept. I think I have to finish with that, and that's the background. I'm sure it raises many questions, but I'm not sure that they could be raised now. So I'll try if there are.
Okay, we have a few minutes for questions, and I would encourage those of you in the audience who want to pose a question to raise their hands and wait for the mic to reach them. Not everybody at once. One at a time. Yes, please.
Sure. Hi, thank you very much for this interesting talk. I'm Kevin from Human Rights First. I have a question for you, Professor Raven-Hansen. You spoke about the issues posed by classified information in federal court cases, and I couldn't help but think about the Guantanamo Bay military commissions. I recently traveled there to observe 1 week of hearings. My fellow intern here, Elizabeth, is going to travel there in a few weeks, and I think anyone would be struck to see how judicially inefficient they are, and to observe that the defense lawyers spent most of their time trying to obtain unredacted forms of classified information and uphold basic fair trial rights, such as attorney-client privilege. So my question to you is, do you agree that the Guantanamo cases should have been tried in federal courts? And I would also be interested in hearing the other panelists' views on this. Thank you.
No, not entirely. I think part of the Guantanamo Bay problem has been that they were originally detained without any eye to prosecution at all. And so chains of custody and other evidentiary precautions that the FBI would take as a matter of course, because they're always looking forward to prosecution, were not pursued there. And after the decision was made to try them, the government was left with a horribly messy file that was not designed for that purpose. And in a way, I think they may have learned, never to do that again. I think there are some of the detainees that are properly tried by military commission, and I think that the military commission procedures have evolved, and the gap between them and civilian criminal trials has narrowed, although there still has a way to go. So with respect to the ones whose status under LOWAC, the Law of War and Armed Conflict, would subject them to trial by military commission, I think that probably that would be an appropriate way to go. But the mistake was, first, evidence was never collected with that end in mind. And secondly, the Bush administration, instead of using court-martial procedures that had a long history, invented military commissions and then filled in the procedural gaps later on. It was an administrative error by that administration that I think we're still living with, but it's not necessarily an indictment of trial by a properly constituted military commission.
Okay. Anyone, sir?
I just want to say, I said before, I don't want to compare and comment. It's another system, and I don't everyone. But I think you actually, maybe this is what you meant when you said it. Things changed from the beginning, from the Bush administration. Those detainees had actually at the beginning, no opportunity to be checked if they are really, this is the right person, if it's the right detainee, if he should be detained, because the concept of the court was at the beginning of the administration, actually. They were caught in the battlefield. This is for the generals to decide what will happen to them. If security people think that they should be detained, they should be detained. This had a change in your judgments, in the law, as much as I know. And after the change, they do have, first, the habeas corpus that they didn't have before, and this is unheard of for a legal system. Now they do. So the developments, this only proves that there is a connection between the constitutional, the political, and the environment in which detainees are kept. And I'm not very happy about how our detainees are kept. I mean, it's also administrative detention, not as we as judges would prefer, but yet I think we have more guarantees because they have access to the court, even to the Supreme Court.
Okay, we'll take more questions if there are. Yes, please.
Andrew Craig from the Justice Integrity Project again. I wonder if any of the panelists have any concerns about the Boston Marathon bomber trial, where we have a very high profile case, and yet no change of venue and very little actual information because of the way the trial was conducted about why the defendants did this. And one could say, well, that was their trial team's decision, but with appointed counsel, a major case, I know some commentators have raised questions about it, and I wonder if any of you have a thought about it.
Peter, you want to take it?
Yeah, I'm not familiar with the details of it, but I will say, what happens with any public trial, one of the reasons that civilian public trials, let me step back for a moment. I think the federal court system is the least dysfunctional branch of our government. The judges I have been in front of are uniformly competent, although many have been wrong, and independent. And one of the reasons that the system has worked as well as it has is the trials are in public, the procedures are preset, we can observe what goes on, and there's an appeal if they get it wrong. So if there should have been a venue transfer, that could be part of an appeal. We could observe what went on. If we don't know why they did it, I think that's partly defense counsel's choice, but if you think that somehow that was suppressed at trial, you should be able to tell that because you could attend that trial. And so by and large, I would be willing to accept the outcome of the typical federal criminal case because the system over 200 years has built a legitimacy that military commissions did not build over the same period. And so anticipating what Judge McCasey says here, I'm not in favor of altering the 200-year-old system because it would put its legitimacy at risk. And so that legitimacy I would attribute to the trial of the Boston Marathon defendants as well, unless you could show me what went wrong.
I thank you for thanking the speakers, and I thank you very much for a very interesting presentation, and I surrender the floor to Ike Zorkin.